Hey, how's it going, everybody? I'm excited to make this video because there's great news in the West Memphis 3 case. We're finally getting a new hearing to determine if there's going to be a new trial, which is a step in the right direction. This is in result of the oral arguments that were held at the Arkansas State Supreme Court, and I have in my possession the opinion of the Supreme Court as a result of those oral arguments. In a nutshell, the argument was over statute interpretation. You had Articles 202 and 208. 202 being the way that Arkansas did business with DNA testing prior to 2005, 208 being the way they did business after 2005 with DNA testing. Basically, first of all, the state was trying to say that, well, Damien got his testing done prior to 2005, so he can't file under 208. And then the Supreme Court said, well, you can't apply that retroactively. So they were called out on that. I'll go into the opinion here of the Supreme Court. Excuse my page flipping and reading. First of all, the Supreme Court acknowledged that the DNA testing results pointed away from the West Memphis 3 and towards Terry Hobbs and David Jacoby. That's awesome. Moving along. Another thing here, the state argued Eccles would not have been entitled to testing under the new version of 202, and as such it would not have consented to testing under the current standard. I just covered that. Basically, the Supreme Court called bullshit. The court, the district court, adopted the state's argument and denied the motion for a new trial under Section 208 Bravo, finding that the DNA test results were inconclusive because they do not raise a reasonable probability that Eccles did not commit the offenses. That is, they are inconclusive as to claim of actual innocence. We disagree with the circuit court's reasoning on this. This is what I love about the finally we're getting people that are competent looking at this case. The Supreme Court goes on, we decline to apply the new testing standard to the incident case because DNA testing was ordered under the previous version of the statute. So what they're saying is the DNA test results stand. It may have been under 202, but guess what? You've got to deal with it. It is evident that 208 Bravo refers to the DNA test results that are scientifically inconclusive and not legally inconclusive. And that's pretty much the basis for the state's entire argument. They were trying to say that it was legally inconclusive, which is a misinterpretation of their own statute, once again. Alright. The state argues that without DNA testing results that could be dispositive of the identity of the killers here, the appellant cannot raise a reasonable probability that he was not one of them. Despite the statement, the state fails to provide any example of when DNA evidence could be dispositive of the identity of the killers, and states in a footnote to its brief that it believes that the forum the statute provides may well never yield relief due to the confidence that the Arkansas criminal justice system does not convict the innocent. Come on, really? You're basically just said that, hey, you may not get relief off of this because, hey, you're trying to prove that we fucked up, and it's just bullshit. So the Supreme Court says we decline the invitation to interpret the statute in this way because it would render it meaningless. This court will not interpret a statute to yield an absurd result. Yeah, you just got busted. While there is a significant dispute in this case as to the legal effect of the DNA test results, it is undisputed that the test results conclusively exclude Eccles, Baldwin, and Miskelly as the source of DNA that was tested. At least they acknowledge that. Alright, and 208 Echo has three parts, the third being one that was argued over extensively here. It states the court may grant the motion of the person for a new trial or resentencing if the DNA test results, when considered with all other evidence in the case, regardless of whether the evidence was introduced at trial, established by compelling evidence that a new trial would result in an acquittal. Dennis Reardon had a little problem with the way the state was interpreting it. He's basically saying that they're saying, well, DNA test results are only valid if it proves guilt, not if it proves innocence. And it looks like that's what the state was trying to do, in my opinion. And then the small blurb, all other evidence in the case, regardless of whether the evidence was introduced at trial. He's several times he said all means all, not just evidence of guilt, but also evidence of innocence. The circuit court's interpretation and application of this subsection was erroneous on each alternative basis. The state gave 3 alternatives as to why they denied Damien's appeal, or his motion for a new trial. I'm really only going to go over briefly. The state answers that the circuit court's alternative reason for denying relief was proper because when considered with all other evidence of the appellant's guilt, his DNA testing results do not establish by compelling evidence that a new trial would result in acquittal. By accepting the state's argument that the DNA test results, standing alone, had to be considered against all other evidence of guilt to determine whether Eccles was innocent, the circuit court read additional language into its own statute. Once again, the Supreme Court called them out. Another alternative ruling. The circuit court held that even if it accepted Eccles' argument about the correct standard to be applied to the new trial motion and credited its proffered evidence, it would nevertheless deny the motion because Eccles fell well short of the stringent showing of a compelling claim of actual innocence. This holding was an error because the court again applied the incorrect legal standard. They're just getting busted at every turn, and I love it. Finally, we addressed Eccles' argument that the circuit court was required to hold an evidentiary hearing prior to ruling on his motion for a new trial. The state does not address this argument in its briefs, and the circuit court's order merely stated that it denied the petition without a hearing. This was error. I just flat out, this was error. That made me laugh. In conclusion, the Supreme Court says, because we hold that the circuit court erroneously interpreted the Arkansas DNA testing statutes, we reverse and remand for an evidentiary hearing at which the circuit court shall hear Eccles' motion for a new trial and consider DNA test results with all other evidence in the case, regardless of whether the evidence was introduced at trial, to determine if Eccles has established by compelling evidence that a new trial would result in acquittal. We hold that because the circuit court interpreted the statutes in question incorrectly, it applied the wrong legal standards to Eccles' motion. Man, this is great news. Finally we have intelligent people looking at this case. I also watched a short video on Arkansas Tech Action in company with Damien's wife, who held a press conference on it. They stated that they would like to just bypass the hearing and go straight to trial, since the hearing will cost the state a big amount of money anyways. So that's what they're trying to go for. And Judge Burnett won't be involved anymore. How cool is that? Even though, because he's in the Senate seat that he's in, he can't be involved anymore. At first I was upset that he was in a higher position of power, because I thought that would give him more power to be involved with this, but it turns out it's the exact opposite. He's gone, baby. So, great news, and I will be providing a link to this document right here, the 16-page court opinion from the Arkansas State Supreme Court, and we'll see whether we're going to be having this hearing or whether they'll be able to bypass that and go straight to trial. It's going to be awesome either way, because we know we're eventually going to trial. Hands down. We got enough evidence to do that. So, great news. Free the West Memphis 3, and God bless.